This is LXBN TV, and I'm Colin O'Keefe. A California woman is attempting to sue Instagram for switching up its terms of service, and so far, it isn't going so well. Joining me today to discuss the suit is Baker Hostetler attorney Alan Pate. He is author on their blog, the IP Intelligence Report. Alan, first, can you explain just the basics of this class action suit? I understand Instagram changed up their terms of service, but why within that is the plaintiff suing?
Sure. Well, back when Instagram changed its terms back in January, they added a few provisions that the plaintiffs view as taking too many rights in users' photographs they upload to Instagram. And on top of that, they are claiming that they're restricting too much how you can go about suing Instagram for later using your photographs.
I see. So second, I understand the case was dismissed from federal court. Why exactly did that happen, and does the class action stand any better chance once it arrives in state court?
Well, it was brought in federal court. It was interesting. It had all state law claims, but it was brought under the Class Action Fairness Act, which is federal law. Basically, lets you bring a class action in federal court if it's above $5 million. Some other requirements, and there's a caveat to the rule, though, where if over 2/3 of your plaintiffs are in the state where you brought the lawsuit, then the federal court just can't hear it. It doesn't have jurisdiction. And that was a problem here. The plaintiff actually brought it on behalf of all California residents who used Instagram, which all is quite over 2/3. So it was dismissed. As far as its chances in state court, it was essentially asserted about the same complaint. They've dropped a claim for right of publicity under California law. But aside from jurisdictional issues, if we get to the substance, and now plaintiffs are really going to have a couple of high hurdles you're going to have to overcome. First of all, there's a provision in the original terms that basically said Instagram reserves the right to update their terms at any time. If you continue using that service after they update those terms, well, you've accepted those new terms. So your breach of contract claims, your unfair business practice claims, it's going to be a difficult hurdle to overcome. The second problem I'd say they have is it's a license agreement. As a user of Instagram, you're agreeing to grant Instagram a license to use whatever you upload. So the plaintiff class have to overcome that argument that they didn't voluntarily enter into that transaction with Instagram.
Absolutely. I think sometimes people believe they have this right to use these social networks and keep them the way they are. But if you're using these social networks and the product that you're using is free, oftentimes your content and your data is the product, not the social network. Once again, that was Alan Pate. He is an attorney with Baker Hostetler, and if you're looking for more of his analysis on this case, be sure to visit ipintelligencereport.com. And of course, if you're not already watching us here on LXBN, be sure to swing by lxbn.com, where we have hundreds more LXBN TV, video interviews, and curated commentary from the LexBlog Network's more than 8,000 members. Thank you for joining me today, Alan.
Thanks.